All right, welcome everybody. So today is the fifth Zoom call that in our series of 6. Today it is titled Tips and Tricks with Stacy Douglas and Greg Atkins. Before we get started, a couple of housekeeping items. We do have one more class next week in the series of 6, next Friday at 9 a.m., so a little bit different day and time. So next Friday, 9 a.m., super excited about that class. That is going to be with Christy Dimmick and with Ariel Martinez. So Christy has a lot of experience working with buyers that buy houses and flip them. And then Ariel actually has flipped, he'll have to tell us how many, lots and lots of houses personally. And he's also an agent. And so come with your questions for that. It's going to be a lot of really good information that you can share when you have buyers questioning kind of that avenue. Today, I need everybody to comment in the comments section that you're here, so you're entered to win today's drawing. There's a really good chance, Angie and Sherry, one of you are going to win. I know we have a lot of people that listen on YouTube. You do need to comment there to be entered to win the grand prize. The grand prize is a Bear Lake vacation up in Garden City, Utah. And so super excited for that. And then also wanted to let you know we do have a bonus Q&A. So, oh, Emily, welcome. Glad you can make it. Our bonus Q&A is going to be on December. Shoot. Just going to put the link in the comment section. I think it's December 12th at 3 p.m. We'll double check that for you. But this is going to be with Aaron Dressel and Bruce Tucker. And we're going to have a 45-minute Q&A session with them regarding the lawsuit that recently happened in Missouri and the pending lawsuits and really what it means for your business. And there's some not bad stuff about it. There's actually some good stuff. We're positioned really well in Utah, but we really want to hear from them how it's going to affect you as an agent going forward. And so be thinking about your questions there. We're really excited to bring that one to you. And just watch your email for the sign-up links, or Tyson, I think, has already put that into our comment section. And so, all right, so let's get on with today's call about title. So briefly, Stacy and Greg are two of my favorite people in all the world. I just think they are really, really high-level professionals. If you haven't had a chance to work with them in the past, I highly recommend it. Their knowledge and their ability to make transactions as stress-free as possible is absolutely phenomenal. And that's why I asked them to be on this call with me, because I just felt their depth of knowledge and their experience. I think they were both saying they've been in the business over 20 years. And so thank you to both of you for taking the time to be on this call. So again, we're going to use the comment, the chat to ask questions. So I've got a few questions that we're going to start with, but if you guys think of anything else you want to ask, go ahead and put the question in the chat box. So first of all, when an agent is going to list a property, I know on the mortgage side, when I get a REPSI and it says owner of record, that's always a problem, right? Mm-hmm. Or if it says John Doe, and then I get the title report, and the title report is in Phenomenon. Anyways, you know, LLC or trust, we have a problem. You guys didn't get my Muppet joke? Really? Oh, sorry. So my first question, and let's start with Greg. What questions can an agent ask to try to get as much information that's going to help everybody make it as smooth as possible when they're starting to list a property?
It's a great question. It's great to be correct to start off with instead of trying to catch up from behind, right? One thing that an agent can do, and I'm sure that Stacy would feel the same way, is just give us a quick call. We can look, we can't really start off with a title search up front, but we can look at the property. We can look at the ownership of the property pretty quickly and give them a pretty good idea of who's the owner. When you're looking at the county records, it can be a little bit difficult to make sure of what you're seeing, because sometimes the county will list a property in different names than is correct. For example, the big one is a trust. The property might be in the name of a trust, but the county will list the trustees of the trust as the owners. So an agent or a lender might pull up the county records and see that John and Jane Doe are the owners of record. But if you search the records, it's actually in a trust, and John and Jane are the trustees of the trust. So they're technically not the owners. It's the trust that's the owner. So that would be number one, is we're happy to look at a property right off the bat to see who the ownership might be in. Also, if it's in an LLC, it's probably a good idea that they pull or start talking with their clients immediately to get business docs, a copy of their LLC docs, to check to see who has the authorization for that LLC to sign. Because you want to, on your contract, start off with the correct signer for that LLC instead of having to backtrack and get the correct signer to re-sign everything. So that's probably two off the top.
Well, a lot of times my underwriter comes back with a condition saying we need proof that the person that signed the Rep C is able to sign for the trust or LLC. And so, Stacy, would you say it's really helpful to have a copy of the trust and all those documents right up front?
Absolutely. We actually, we prefer it when we first get, have someone reach out to us. The first things we're doing is searching the county website and checking to see what the last deed was recorded, because I want to make sure that we have the most accurate information. When we come to a trust, we need to know who has the authority, just like Greg was mentioning. We need all the documentation up front so we know how to prepare things. And it also helps eliminate any delays when we're trying to get the contract updated or an addendum stating who is the actual seller versus what's been on title and what they originally put on there. So it's important to have all that documentation. The trust is important too. And I know a lot of people think that when they have a trust, that the trustees are always the ones that has the full authority on there. They may have the authority to sign, but they need to consider the beneficiaries of that trust as well. And a lot of people don't think about that. And as real estate agents, you need to make sure you're having that documentation when you're getting your contracts. Otherwise, your contracts are going to be incomplete. And same thing with the lenders, they're going to require it as well. And one other thing I wanted to mention about the trust, some people are misinterpreting what a power of attorney does in a trust. Not every trust has a power of attorney. And so we have some people that come to us and say, well, I've got the trust, I'm not the trustee, but I have a power of attorney. And unfortunately, unless the trust states that, that power of attorney doesn't do anything for us.
Well, that actually goes kind of right into another question about powers of attorney, right? Mm-hmm. And so if you know that as an agent, that your seller, say it's a couple, and one of them is going to be out of the country at the time of closing, it's really common to get a power of attorney. So how do you guys advise people when they say, hey, we need a power of attorney?
Good question. So for what we like to do is first we want to understand why we're getting this power of attorney. And we need to know, because some people already have one put together. And depending on the type of power of attorney, our company is we want something very specific. We don't want a general power of attorney. We want something specific to the property.
Would accept a general, like
there's some out there that will do it, but I know lenders want something more specific. They don't want something general. Yeah. And so having that, knowing exactly what type of power of attorney and why they're wanting to do that is something you should be having a discussion up front. Those are conversations that you can know with your clients. Do you plan on being in town? Is there a chance that you're going to need to have a power of attorney? Because there are times where we do need to have one. But asking those questions up front and understanding the circumstances around their situation is very important. Then it eliminates that at the very end when we have to create a power of attorney and we're rushing to do that. Sorry, Greg.
That's exactly what I was thinking. Let's not rush to the end. No. We have thousands of problems that we work out from the start to the end of a transaction. And a problem is super easy to work out at the beginning. There's literally no stress to getting a power of attorney. But when it happens, and I've seen people forget that they added their kids on title, right? And when that happens in the end, now that problem is a crisis and everyone's stress level goes up. So Greg, your thought, anything on that?
I actually really appreciate what Stacy was saying, because those are two things, just going back to the trust and the power of attorney, because we do hear that quite often, that argument that I can sign, I've got a power of attorney, but it's in the trust. I would say for most cases, as an agent, you can just plan on it, that it's extremely rare that your trust is going to allow for anyone to step in with the power of attorney. It's out there, but it is rare. So if anyone brings up the fact, well, I can sign, I'm not the, I'm not the trustee of the trust, but I can sign because I've got this power of attorney, I would default back to, that's not going to work, because I would say 99% of the time, it's not going to work. They're not built into the trust. The whole reason for the trust is to spell out who's signing. So a power of attorney and a trust just don't go together. So that would be red flag number one. And with the power of attorney, we're the same way. Our company's the same way as Stacy. A power of attorney, to get that done, you can count on getting a new power of attorney. So if someone brings to you a power of attorney that says, I've got this general power of attorney, or we did a power of attorney off the internet, you can kind of count on us saying, well, we're going to need a new one. So they're going to have to, so this has come up before, and we basically say that the seller is going to have to sign a new power of attorney, a specific power of attorney. So they come back with the answer, well, if they have to sign that, they might as well just sign the documentation. Yeah, that's right.
Yeah.
They might as well. And then also you can plan on, if we're going to get a power of attorney, then you could probably tell your clients that they can plan on a phone call from the title company asking them why they need that power of attorney. What is their specific case for needing a power of attorney? And not everything will be accepted by our underwriters. It's pretty limited. Military, travel sometimes, but if they can get to somewhere where they can sign with a notary, we want them to do that. Yeah. So it's definitely not a quick fix.
Okay. Well,
can I add one more thing to that? Do you mind?
Yeah.
I know that when we were talking about entities, that's another thing that we get. People think that they can use a power of attorney with LLCs and other types of entities, and that's not always the case either. So they need to be very careful on those entity documents. As real estate agents, you need to make sure you're getting a copy of if it's an LLC, articles of organization, partnership agreements, the articles of incorporation if it's a corporation, because that documentation, just because that person is representing and saying that they're the ones that have the authority, they may not have the authority at all. And we come across that all the time. Or one says, I can sign by myself as a manager or a member, and in fact, they actually can't sign. They need to have two signers. So it's really important to know that, because I have contracts come over where it's only one signer on there, and then we get the documentation. It's there. We need two signers. So that would help eliminate, the delays and having to have addendums and things like that, especially for our lenders.
Yeah, I think that's great. And so now in the mortgage world, we're actually able to do 90% of the documents electronically at closing. I don't like to do that like with first-time home buyers or I get to know my people. Some people, they want to be there. They want to see everything. But it does allow, but an interesting thing about that, as we veer towards more a world of e-signing, is that right now in the mortgage world, you cannot do a power of attorney plus an e-signing. So unfortunately, if you're doing a power of attorney, the person signing is going to have to sign all 50 I don't know how many, let's say 29 documents for both them and if it's like a husband-wife situation, for them and for them, the ones for themselves and for the person that with power of attorney on. And so in some cases, it might be easier to do electronic signatures on 90% of the documents and then do some type of a remote closing for the person that's not in town. And then we did get one question for Emily. If one spouse is out of the country, can the other spouse be their power of attorney? Absolutely. That's a lot of times what happens.
Yes.
So good question on that. All right. So another question, I want to talk a little bit about divorce, because I think that divorce situations and property, there can be a lot of moving parts. And as an agent, when you're working with a couple, you've already are in a really difficult position because you're almost a mediator, right, between those people. And so having the knowledge up front of what you need to share with them about title and how it needs to be handled is really important. So, Greg, let's start with you. I want you to just share some of the red flags with divorces and how agents can prep their clients to make it as easy as possible to go through that situation.
I think some of the red flags with divorces would be, from a title standpoint, if any one of the spouses are calling in and giving us instructions of how to tackle one thing or another, maybe with an agent, they're giving them instructions of selling this way or that way, and just saying, hey, this is what we decided, and I'm taking care of it. This is what I think. This is what we're going to do. You just got to be careful. Then make sure that you're getting both views, both sides, in writing of how they want funds distributed. You know, besides the divorce decree, you'll have parties call in and say, hey, we decided to do this, or we decided to send me this, without hearing from the other side. Sometimes people are trying to be a little sneaky, sometimes not, but you just want to make sure that you've got that in writing from both sides, or you have something, an agreement from both sides, and not just take one side's word for it.
Okay, I like that. And so, Stacy, I'm not sure I'm going to say this right. Lis pendens.
Okay, so Lis pendens, are you
Explain that.
referring it to a divorce?
Mm-hmm.
Okay, so and what we're starting to see more of, and Greg can attest to this, is that we are starting to see the domestic relations injunction being recorded, and that is very important for real estate agents to be aware about. And we provide a copy of the information, but it's another thing that they're doing with the divorce decree. A lis pendens is more so. Oh, sorry.
Before you go any further, so with that, is that something that you, if an agent calls you, hey, I'm listing this property, without doing a PR or whatever, a title search, is that something that you'd be able to pull up to share with them?
Yes, if it's been recorded, depending on where they are at in that process, if it's been recorded, then yes. And that is where we get our instructions now, not just based off of that. And as far as back to as a real estate agent needing to know and understand that holds everything. It does not give them authority to sell, to determine equity or anything like that. So if one is recorded against the property, in addition to the decree, then you could be in trouble if you're putting a contract together and trying to list and sell a property that hasn't been agreed upon with the courts. I don't know if you're seeing that, Greg, or not. Those injunctions are now being recorded a lot more than what we've used to see. Before it was just the divorce decree, but that's important because it actually states it halts everything. No spouse can make a decision on anything. So it's really important to know that. If you see that come over on your PR, hopefully your escrow officer is bringing it to your attention way beforehand. And like Greg had mentioned before, if we can take some steps to be proactive when you're sitting down with your clients and asking them what circumstances they've got going on in their lives. And some people are very upfront. Some people don't feel like that they need to share that with their real estate agent. They just want to sell their home and they're going to deal with the equity. They don't understand there's things that we have to have in place in order for that to happen. Just like Greg had mentioned as well, that just because one spouse calls us and says, hey, we want you, we've made some arrangements, we're going to change this, I want you to pay this off and pay that off. It's so important to make sure that as a third party, even you as a third party, is making sure that you're being transparent with everyone and that they understand that, yes, they may be able to come to an agreement on their own, but we need something in writing. We need to make sure the attorneys are also going to be okay with that because sometimes they're not. Sometimes there's other things that we may not know about and they're handling things on their own. And then they're not following the domestic injunction. And so it's just really important to have those a list of questions that you want to ask people. And then also I have this thing I'm happy to send to people. It's called If Circumstances Change. These are reasons why when you need to contact your agent or your title company.
Oh, awesome. Well, and I think that a lot of people don't realize that in the mortgage world, we actually cannot do a mortgage for someone if a divorce is started but not finished. So if what did you call that thing again? What was the word you used?
It's domestic relations injunction.
So Liz Penson's or an injunction, right? If anything is recorded or and there's any red flags that a divorce is started, we actually can't do a mortgage because we don't know the financial obligations that are going to result in the final divorce decree. And so in some ways, so crazy story. Years and years ago, I used to do my own closings. I was a notary, and I had a guy come in and brought his wife with him. It turned out not to be his wife. He had taken his wife, who he was separated from, her ID, and they looked similar. They were Asian. He wasn't even living in the house, and he did a cash out refinance. So, I think it's in the best interest of both parties to do some type of an injunction or something to protect the integrity of that property until decisions have been made. So a question we got from Angie, is it better for us to talk with our clients in a divorce situation or have title or loan officer? How do we explain things so it buffers the anger? That's a great one.
Yep.
Yeah.
I think, you know what? It's really hard. It is so hard when you have a couple that is going through so much. I mean, it's very challenging. It's hard enough to sell a home, when you're not going through a divorce, and then you take in a divorce, the emotions are real. And so sometimes it is easier to have your escrow officer have those kinds of conversations, because most of the things we need to have anyway, and then we can provide that with you. I am sure Greg agrees that sometimes it's easier when you have someone else, a third party, talking about those conversations and having those conversations with you.
Yeah, I think that's good. Greg, what are your thoughts on that kind of touchy situation?
That I actually agree with Stacy that sometimes it's easier for a third party title company to get in there and discuss some stuff, because we can almost kind of take some of the emotion out of it, I think, and just kind of just say, these are the facts, this is what we have to do. We sometimes will get people in that feel like their divorce decree, their divorce is final, it's been taken care of, it was done a year or more ago. But title wise, we still need maybe some documentation to be recorded that would clear that interest a little bit better. And so even if one person might think that this is done and this is in their name and their property, and they don't have to worry about bothering their spouse with anything anymore, there's a pretty good chance that title is going to need to make a phone call and get an additional document signed, like a quit claim or something like that, that would correctly remove that interest from a spouse, an ex partner from a while ago.
I actually have a story that would be a good example of a way you could advise your client. So this gentleman owned his house before he got married. And I don't know the time frame of it, but he got married, and then let's say 5 or 7 years later they were getting divorced. And he ended up getting 7 different appraisals. If his wife wouldn't accept anything, he ended up having to pay her what I thought was enormous amount of equity that I didn't think was fair. But obviously I'm not part of any negotiating, and I didn't share that with him. But from what he told me and the numbers I could see, because it drug on for over 2 years, and this was between 2019 and 2021. So think about what values did. She had moved out in 2019, but we get to 2021, it's still not resolved, and she wants the equity based on 2021. And so my big thing is, especially agents, sometimes you start talking to people that might be going into that situation, is work with your mediator, get something in writing that says this is the value of the house the day you moved out, because it may be a whole long ways down the road when you actually consummate something to give the equity. It's worth the money for an appraisal or something, just to protect both parties. In my mind, that was just a really, really sad situation where he just lost so much.
I've seen it a lot. That's a good example. Another thing is sometimes you have an uncooperative spouse, that, like this lady, we see this all the time. And one thing that we have to always go back to is what the divorce decree states. That's usually what we're going off of. And we're talking with the attorneys as well to make sure, because one other issue that we come across too is that if the divorce decree is ambiguous, I mean, that's there. And most of the time they are. There's very few that I see where it is just like straight, you know, it's to the point, it's outlined in detail, and you know exactly what your instructions are. But sometimes what happens is at the time of the divorce, they may not be in a position to sell right now. And so if the value is based off, what their equity is based off the value of that time period, when they're going through the divorce decree at that year, let's just say 2023, but he's not going to sell it until 2000, you know, and 30, where obviously the value is going to be a lot higher. We need to make sure what that's based off of. And if they're not dealing with that, then we also want to make sure, as Greg mentioned, a quitclaim deed. We need to get that. We need to make sure that we're getting that quitclaim deed signed immediately when they go through that divorce. Because if you have an uncooperative spouse down the road decides she doesn't want to, you know, sign the quitclaim deed, or the, you know, or the husband doesn't want to sign it, trying to get them to, you know, come in and get it taken care of could delay a lot of it could delay the whole process.
Yeah, I actually have it's fairly often, well, not fairly often enough, we'll have a past client call me to say that they're in a divorce situation. And my advice to them always is make sure that through your mediation and the divorce proceedings, that the final divorce is very, very specific. I want to see the account number for the mortgage. I want to see whose responsibility is for the mortgage. I want to see, if at all possible, a dollar amount of the equity to be paid to the non-occupying spouse that's leaving the home, because their life will be so much more simpler, right? They're going through so much trauma already. Be very, very specific. So I'm sure as agents, you guys get that question. You have your past clients reach out as well. And that's just one thing we can help them with. So cool. All right, let's move on. All right, seller financing. So Stacy, I know you actually have done some classes on this. I personally bought my first house on seller financing because it didn't have a foundation and I was dirt crap poor. And I've sold 2 houses on seller financing for a short time. And it worked. All 3 of those scenarios worked out really well for me, luckily. Super high risk, right? And so, Stacy, give us kind of the 60-second overview of seller financing and how an agent can advise their client that says, I want to find a house with seller financing.
Yes, it's a good question. We're getting that a lot. Seller financing is wonderful depending on the situation and the circumstances. The one thing that people have to understand is there is risk to it, and making sure that your clients understand all the risks up front, and the buyers have to understand all the risks up front. And so making sure that we're having that conversation, you're putting things, you're documenting it and putting it in writing. But the whole process is depending on the type of seller financing. There's different types of scenarios. The one that we see the most is what we call a wraparound. I'm not sure how familiar most of you guys are about that, but most homes usually have a mortgage on it. And so the ones that we've been seeing is that there's a wraparound. And so we're having to make sure we're getting the right documentation, the full disclosure on everything. The seller financing addendum is being completed. And there's different ways that we can protect the seller and also protecting the buyer with certain types of documentation. And so it's just important to make sure that the full disclosure. But on how it's processed is the seller obviously is the bank now. And so if they do have an underlying mortgage, we suggest that they work with a company. I like Escrow Specialists. There's a few out there, but Escrow Specialists seem to be the one that's worked the best for my clients. And then we just get all the documentation ready for it. We help create the note and the deed of trust. We help facilitate some of the other documentation for the transfer of it to Escrow Specialist. But I always tell people, you should also consult with an attorney as well, because I think it's really important for both parties to understand where the liability lies, and helping with the negotiations, because we don't do that. And I have a lot of people call me that don't have a real estate agent, and I won't work with them, unfortunately, because they need to be protected. It's a big deal. Seller financing it's a great option and it can accomplish a lot of things, but it's a big deal.
Yeah. Well, and interesting enough, over the last couple of years, I've worked with Greg on a number of short-term financing situations that I've done to help facilitate a future mortgage, right? Someone can't sell this house And so put a lien against this house, put the down payment on this house. And so Greg, tell me kind of your, just in your opinion, some things that with like, I don't know if you call it bridge financing, short-term financing, what are some things that agents get questions about that from their buyers or sellers? What's some advice you can give them on that?
I would just make sure that if you're doing anything like that, short-term financing, bridge financing, anything like that, you just want to do it correctly. When I say that, I mean you want to have the correct documents done. You want to create a note. You want to create a deed of trust that's recorded in the county records. You want to have documents signed and not just a handshake agreement. Especially with that note and deed of trust, people will go back to a mortgage, and you can speak to this, but they'll go apply for a conventional loan later. And it's difficult if they don't have a note or a deed of trust that's done and recorded correctly and that they can reference and provide that to their lender down the line. It's going to be difficult to get a mortgage loan, or it'd be more difficult where the lender's going to want to see that note. They're going to want to see that deed of trust. They're going to want to see it recorded and the timestamp of the title report so that they can basically do a refinance down the road. So I would just want to make sure that if that's what you're going to do, that you create the correct documents and do it correctly and record it correctly so that your next steps down the road are easy and not complicated.
And I know, Greg,
also documenting those payments, because that's another thing, sorry, Les, as a lender,
that's really
that's
important.
why I always refer people to escrow specialist or having someone take that payment and documenting that payment and reporting it so the lender can actually facilitate a refinance, because you're going to look at that as well.
Yeah. On the private loans that I have done, basically, I set them up in my mom's name because I can't have a private loan and be the lender on their next transaction. And so they just Venmo. We have it all set up exactly where their payments are going. They Venmo my mom every month. And so when we get ready in 2 or 4 months to do that next loan, we can show that history, because you're right, Stacy, that's really important that we document their payments. And like Greg said, you've got, it can't just be a handshake, because if it's just a handshake, unfortunately, if they need to do financing to pay off that handshake, it now is a cash out refinance, which has multiple layers of different rules. One of them being, it's recently changed. Tyson, is it 6 or 12 months you have to be on title? We're not doing refinances right now, so I don't remember.
I think it's 6.
6 months.
Okay.
Or maybe it just changed to 12.
I know,
Well, it was 6 months, so I think you might be right, Bliss. 12 months. It might have switched that, because I just started getting some documentation from our underwriters on that.
I can only.
So how about you, Greg? Have you seen anything?
I haven't. I wouldn't be able to answer that one.
So
now that we're talking about it, I'm pretty sure it's 12.
Yeah, I think it did change, but I can only emotionally handle so much change at one time. So because I know I'm not doing cash out refinances very much right now, but yeah, I think it is 12. So that's a big deal, right? But if you do it with a note and a trust deed, and you can prove it's been 2 months and you can prove 2 months of payments, that's a rate and term refinance. So the documentation, the time frame is less, and you also get a better interest rate. And so cash out interest rates are higher, especially on high loan to value. So you can do a 5% rate and term refinance, but you cannot do, 95%, but you cannot do a 95% cash out. And so there's a lot of things there if you're looking at some bridge loans and some things like that, that's really important to be aware of with title to make sure it's done correctly. So I appreciate that information, guys. Thank you very much. All right. Property fraud. Kind of want to talk about property fraud for a minute. Just what are some red flags that agents can watch for, and how can you guys help mitigate property fraud? Greg, let's start with you on that one.
A big red flag is time. Someone from out of state came into this property or knows somebody that is selling a lot that needs it to be done immediately, is in a rush. The values don't line up really correctly. Maybe it's cheaper than what you think it should be worth. And someone that's a little bit overbearing on, you don't need this, you don't need that. I've been in this business for this long. You shouldn't need those documents, or you shouldn't need to bother me about that. Anyone that's trying to strong arm you to rush something through. I've seen that happen before, and we've had stuff come through our office that throws up red flags, especially with the values not being really there. A lot sale is probably one of the bigger triggers. Somebody it's vacant property, and then also someone that's not able to, it's a little bit different, but you have to look at their identification that they're providing as well. You know, sometimes you have to ask for identification up front if you're questioning a deal, and make sure you get that, and that all checks out. There are some identification services. We're actually getting online with one now that will run licenses, driver's licenses, to make sure that they're valid and not forgery. So
Nice.
just some things out there.
Yeah. All right. That's fabulous. All right, Stacy, what are your thoughts on property fraud, or your
So
experience?
it's out there, it's real. And to add on to what Greg said, because all that is good stuff. Red flags are international buyers, or sellers coming in saying that they've been overseas. I've seen that a couple of times. They've been overseas. They only communicate through text. They'll call you, but they don't want to Zoom. They want to handle their own notaries on their documentation. They want to handle certain things on their own, and they don't want to provide us with documentation like Greg had mentioned. I just recently had one come up on a property where there was a spouse. He was married, but he's remarried, I should say. And his wife had the same name as his previous spouse. And they came in, and he was trying to sell the property without having to pay her out, saying that they got back together and this is them, and provided identification and everything. Well, after we started doing more research, and I was like looking at the signatures, they weren't comparing with what I currently had on my previous documentation. So just really doing your due diligence, really paying attention. You have to question everything now, which is unfortunate, but
Wow.
yeah, there's a lot out there. I have a great flyer I will send to you, Bliss, and you can send it out to your people, that talks about what to watch out for and how it's being impacted here in Utah.
So Tyson, question for you. On the YouTube channel, when we post these, can we post a document like in the comments? Is that possible?
No, I don't think so. I think it's just text.
YouTube.
Well, we
Okay.
could do like a link to a Google Drive, I think.
Yeah, let's do that. I love that, because I think that would be really valuable. Wonderful. Well, we're gonna have just a few more minutes. All right, boundary line dispute. So Tyson had a transaction exactly a year ago. How long did that get held up? Like 3 months? 2 months?
I think it was closer to 6. It was
6 months.
well, maybe, I don't know. It felt like 6 months of it wasn't.
Yeah, exactly. So Stacy, what are red flags for bond? How do we know there's a boundary line dispute? How do we discover that before the appraisal or something's done? Like, I don't really understand that. And how can realtors understand it?
Very good question. So first and foremost, when you're sitting down with your clients at the listing, you need to be asking questions like, are you aware of any encroachments on from your neighbors with any landscape? When you purchased the property, was anything disclosed to you about any of the boundary lines? Have you ever walked your property? Did you ever survey done on your property? You know, just asking questions up front. Sometimes people just don't even understand that there's an encroachment because they're just not familiar with the terminology or the situation. And so once you start opening up and asking questions about the land and about the property, then usually they'll say, oh yeah, you know, my neighbor's tree is encroaching on my property, or this or that, because those are things that need to be disclosed up front. A fence line. We get a lot of problems with fences. People will not have a survey done. They'll just go put the fence up. This is where it is. Both my neighbors and I agree to this. And then you have someone, you know, then they decide to sell the property and someone else comes in and they want to do some landscaping, and now there's a problem. And so obviously there's laws put into place to help protect people from that. But But you do need to be asking those questions up front. And most people, when they buy a home, they don't walk the property with their agent. It's very rare that they do that. Usually in new construction, it's done more. Greg might attest to that. But most people don't walk their property. It's usually in the subdivision and they're just taking the lot lines as the boundary line.
Yeah.
But yeah, a lot
interesting.
of people have more encroachments than they think.
The property that we sold last year, almost 2 years ago in Lehigh, Stacy, you're familiar with it. But our fence line was actually about 12 feet into the property behind us because it was the farm fence line. And we knew that. And then when the development went in, we had a conversation with the people that were building and they were like, well, yeah, that's 12 feet in my backyard. Of course I want it. And we just, the guy actually did the whole new fence himself. Like, it was very amicable, but I could see where I could have sold that property. Nobody really paid attention. The people that bought my property could have thought that the fence line went 12 feet long further because that's where the fence was for 8 years.
Sure.
And so definitely a problem. So yeah, very good questions to ask up front. Greg, last question is for you, and Stacy, feel free to chime in too, about water. I know water can be a big issue. So kind of talk about that and what an agent can do in situations that might involve water.
That's a really good question. Water is one that comes up sometimes, not too often, especially on just a basic residential deal. But there are a couple of different types of water out there, a couple of main ones. One is with irrigation companies, local irrigation companies. There's a bunch. People have water shares for a portion of water with that irrigation company. They should have those in possession. And at the time of transferring the property, they can transfer those over to the new owner. They'll sign the back of those shares over to the new owner, and then the new owner will take those down to the irrigation company and pay a fee, usually around $40, $50, and have new shares created in their name. It's pretty simple. Title does not get into the research of water. They don't get into the insurance of water transfers, and they don't get into searching what water rights would be transferred. You know, if they get a contract that comes through and says, hey, look at the water, then that will be deferred back to the seller to provide us with what type of water do you have on the property. So the number one is that water shares. They might have water that's registered with the state of Utah through their water division. And if that's the case, then a third party water search company would be hired to do a water search on the property. For the most part, they'll do a chain of title that would kind of track back maybe an owner or two, because it's not always up to date. It's usually not up to date, and kind of tie those water shares back to who the current owner is. And then they'll do a water transfer deed that's sent to title to have signed at closing, and they kind of can have that signed at closing and then send it back to the Division of Water Rights, and then they can record it in the right name. Those third parties will also offer water insurance if you want to pay for that. Sellers and buyers can negotiate who will pay for that water search, and if insurance is required, then they can negotiate who would cover that cost as well. So those are two of the main water types out there. Usually the water shares are just shares that people have on them, and then if there's a well on the property, that usually is a sign that it's going to be registered with the state of Utah.
Okay. And actually, we do have one more question, and I am so glad you asked this, Emily, because I think it's super important. Have either of you had to use the insurance policy for disputes? It seems like it would be rare, but then again, it's not my realm, so I'm not really sure. I actually get people ask me, I was like, title insurance, whoever uses title insurance? And I personally have heard kind of third hand, but I don't know anybody that's ever had an insurance dispute. So Stacy, can you answer that question?
Yeah. Well, I've been doing it long enough, and like Greg, you do come across that. I actually think that's one of the great things about title is that we do have a great policy in place to help protect people. I've had signature fraud come up where we had, they provided us with wrong documentation, and our title insurance policy covered that. We had a situation years and years ago where we ordered a payoff through I can't remember what company it was. It's out there. I'm trying to think. I can't remember. Anyway, from a company, and they had been hacked on their end and through their systems. And so we got a payoff that was incorrect, and we funded the payoff. And so our title insurance policy kicked in and covered that for the clients, over $80,000. So the
Wow.
policy is great, and it's there to be used
you
when
need
you
it.
need it.
It's
Hopefully you don't
really
ever need it, just like other insurance, but yeah, it's definitely used.
Well, and Angie
Just
put on
to-
here that she's used it twice. Angie, what on earth? Twice?
Twice.
Yeah, in fact, so just 2 years ago, I represented a seller and the title company got hacked and they wired 480,000 to a fraudulent account. But on my personal, we bought a rental at the county court steps. In fact, Greg, it was with Utah First. County court steps, bought it cash. Then we deeded it into our company name, our investment. Then we refinanced and got a loan on it and put it back in a personal name and then put it back in. But the previous owners, the ones that were foreclosed on, came in and sued us and said that we were doing straw buyers and ended up, I don't know whatever ended up happening. I know that title insurance took over, but we were getting sued and there was nothing fraudulent we had done. It just appeared because like you guys said, their title had changed so often.
Yeah.
Awesome.
And then the other one was where there was a lien that was not paid off and it was missed by title. And then we didn't have, it was so cool because we got the notice and we went to the title and they said, oh, we'll take care of it. Title insurance will take care of it. We never heard back.
Good to know.
That's
And
good.
Greg, you were going to add something on that as well.
Oh, I think that's great. I was just adding to the fact that the wire fraud is out there. We've been hit with it as well. So, I mean, it's just out there. And title insurance, it's one of those things where you hate to see that number on the page, but if you have it and you have to use it, you're glad you paid for it.
Absolutely. And, because I have originated loans in Texas and Oklahoma as well. We're not an attorney state, right? We don't have to have title insurance. And so, I'm sorry, title attorneys involved. So I think Utah does have a little bit less fees on the title side than other
we
states do. And so I'm really grateful for that. But, Stacy said, or Angie said, also my seller's title company got hacked and the title company wired 480. Oh, can you imagine? You just crap your pants. If
Yes.
that happened. Well, maybe not exactly that. I'd come close. All right. So you guys, this was such great information. I really appreciate it. Most people don't understand title work, title insurance, escrow officers. They don't understand that part of the transaction. So this has been really helpful. I think that it's really important that real estate understand the resource that a good title agent can be to them. One of the things that Stacy mentioned at the closing I went to yesterday, she actually gives information about utilities to buyers for the areas, right? And so title companies, and like how Greg has helped me with some private financing situations, there's such a resource to real estate agents. I just can't stress enough the value of having these strong relationships with a title person. So thanks, guys. I really appreciate the time. And I hope we see everybody next Friday on our property flipping Q&A. Thanks, guys.
I'm excited. Thanks so much. It was great to be here, and I'll get that information sent over to you.
Great. Okay. Appreciate it. Thanks, guys. Have a good day.